Welcome to our deep dive into non-compete and non-solicitation agreements. These legal tools are increasingly common in employment contracts, but many people aren't sure what they really mean or how they affect their careers. In this video, we'll break down the basics, explore their purposes, and help you understand your rights and obligations. Whether you're an employee, employer, or just curious about workplace law, this guide will clarify the essentials and set the stage for a detailed exploration. Let's start by defining what these agreements are and why they matter in today's business world. Non-compete agreement is a contract between an employer and employee that restricts the employee from working for competitors or starting a competing business for a certain period after leaving the company. The goal is to protect the employer's confidential information, trade secrets, and customer relationships. These agreements typically specify a timeframe, geographic area, and types of businesses covered. Understanding these details is crucial as they can significantly impact your future job opportunities. Let's look at how non-competes are structured and what you should watch for in the fine print. Non-solicitation agreements are designed to prevent former employees from poaching clients, customers, or other employees after leaving a company. Unlike non-competes, which restrict where you can work, non-solicitation focuses on who you can contact or recruit. These clauses are common in sales, consulting, and industries where relationships are key. They usually specify a duration and the types of contacts covered. Understanding the scope of a non-solicitation clause is essential, as violating it can lead to legal consequences. Next, we'll compare these two types of agreements and highlight their differences. Both non-compete and non-solicitation agreements aim to protect a company's interests. They do so in distinct ways. Non-competes limit where you can work, while non-solicitation restricts who you can approach. The scope, enforceability, and impact on your career can vary greatly. Employers often use both to safeguard their business, but employees should carefully review each clause. Knowing the differences helps you negotiate terms and avoid unintended consequences. Let's move on to why companies use these agreements and what they hope to achieve. Employers rely on non-compete and non-solicitation agreements to protect their business assets. These include confidential information, trade secrets, customer lists, and employee relationships. By restricting former employees' actions, companies aim to prevent unfair competition and maintain their competitive edge. These agreements are especially common in industries with high turnover or valuable intellectual property. Understanding the employer's perspective can help you see why these clauses are included and how they shape workplace dynamics. Next, we'll discuss how these agreements are enforced and what makes them legally binding. Enforceability of non-compete and non-solicitation agreements depends on several factors, including state laws, the reasonableness of restrictions, and the specific language used. Courts often scrutinize these agreements to ensure they aren't overly broad or unfairly limit an employee's ability to earn a living. Some states, like California, generally refuse to enforce non-competes, while others allow them with limitation. It's important to know your local laws and consult legal experts if you're unsure. Next, we'll explore what makes an agreement reasonable and how courts decide. Courts look for reasonable restrictions in non-compete and non-solicitation agreements. This means the timeframe, geographic scope, and type of work or contacts must be fair and not overly burdensome. For example, a one-year restriction in a specific city may be acceptable, but a 5-year ban across the country is likely too broad. Employers must justify their need for protection, and employees should ensure the terms don't unfairly limit their career. Understanding what's considered reasonable can help you negotiate better terms and avoid legal trouble. Non-compete and non-solicitation agreements often include specific clauses outlining the restrictions. These may cover the duration, geographic area, types of businesses, and prohibited actions. Some agreements also include confidentiality clauses, ensuring sensitive information remains protected. Reviewing these clauses carefully is essential, as each can affect your future opportunities. Next, we'll look at examples of typical language used in these contracts and what to watch for. Typical non-compete clause might state, the employee shall not engage in any business that competes with the employer within a 50-mile radius for 1 year after termination. Non-solicitation clauses often read, the employee shall not solicit any clients or employees of the company for 2 years. These examples highlight the importance of clear, specific language. Ambiguous terms can lead to disputes and legal challenges. Always read the fine print and seek clarification if needed. Negotiating the terms of a non-compete or non-solicitation agreement is possible and often advisable. Employees can request shorter durations, smaller geographic scopes, or exclusions for certain types of work. Employers may be willing to adjust terms to attract top talent or avoid legal challenges. Knowing your leverage and understanding the employer's needs can help you reach a fair agreement. Next, we'll discuss strategies for successful negotiation and what to prioritize. Effective negotiation starts with understanding your goals and the employer's concerns. Prepare by researching industry standards and local laws. Be clear about what you want to change and why. Offer reasonable alternatives such as limiting the scope or duration. Document all changes and ensure they're reflected in the final agreement. Negotiation is a two-way process and both parties benefit from clarity and fairness. Next, we'll look at the risks of ignoring or violating these agreements. Violating a non-compete or non-solicitation agreement can lead to serious consequences, including lawsuits, financial penalties, and damage to your professional reputation. Employers may seek injunctions to prevent you from working or contacting clients. Legal battles can be costly and stressful, so it's crucial to understand your obligations and avoid risky actions. If you're unsure about your agreement, consult a legal expert before making any moves. Next, we'll discuss how to handle disputes and resolve conflicts. Disputes over non-compete and non-solicitation agreements are common, especially when terms are unclear or overly broad. Resolving conflicts often involves negotiation, mediation, or legal action. Start by reviewing the agreement and gathering evidence. Open communication with the employer can sometimes resolve issues without court involvement. If necessary, seek legal advice and consider mediation before pursuing litigation. Understanding your options can help you protect your interests and minimize stress. Non-compete and non-solicitation agreements are governed by state laws, which vary widely. Some states strictly limit or ban non-competes, while others allow them with restrictions. Understanding your state's rules is essential for both employers and employees. Research local statutes and consult legal experts to ensure compliance. State law can affect enforceability, penalties, and negotiation strategies. Next, we'll look at some examples of state-specific regulation. California is known for its strict stance against non-compete agreements. The state generally refuses to enforce them, prioritizing employee mobility and competition. However, non-solicitation clauses may still be valid if they're reasonable and don't overly restrict business practices. Employers in California must find alternative ways to protect their interests, such as confidentiality agreements. Understanding local rules is crucial for anyone working or hearing in the state. States like Texas and New York allow non-compete agreements but require them to be reasonable in scope and duration. Employers must justify the need for restrictions, and courts may modify overly broad terms. Non-solicitation clauses are generally enforceable if they protect legitimate business interests. Knowing your state's approach helps you navigate negotiations and avoid legal pitfalls. Next, we'll discuss how these agreements affect job seekers and career planning. Non-compete and non-solicitation agreements can significantly affect job seekers. Restrictions may limit where you can apply, who you can contact, and what roles you can pursue. It's important to review agreements before accepting a job and consider their impact on your career trajectory. Employers may use these clauses to protect their interests, but employees should ensure their rights aren't unduly restricted. Next, we'll explore strategies for job seekers facing these agreements. If you're a job seeker facing a non-compete or non-solicitation agreement, start by reading the contract carefully. Ask questions about the scope, duration, and exceptions. Negotiate terms if possible and seek legal advice if needed. Consider the long-term impact on your career and weigh the benefits of the job against potential restrictions. Being proactive can help you avoid surprises and protect your future opportunities. Employers can use non-compete and non-solicitation agreements strategically to protect their business. It's important to draft clear, reasonable terms and comply with local laws. Offering incentives such as severance or bonuses can make agreements more attractive to employees. Employers should also review agreements regularly to ensure they remain relevant and enforceable. Next, we'll discuss alternatives to these agreements and other ways to protect business interests. There are alternatives to non-compete and non-solicitation agreements that can protect business interests without restricting employee mobility. Confidentiality agreements, intellectual property clauses, and robust onboarding processes can help safeguard sensitive information. Employers may also focus on building strong relationships and positive workplace culture to retain talent. Exploring alternatives can lead to win-win solutions for both parties. Confidentiality agreements, also known as NDAs, are a common alternative to non-compete clauses. They focus on protecting sensitive information rather than restricting employment. NDAs can be tailored to specific needs and are generally easier to enforce. Employers and employees both benefit from clear expectations and legal protection. Next, we'll look at intellectual property clauses and their role in safeguarding business assets. Intellectual property clauses protect inventions, designs, and creative works developed during employment. These clauses ensure that any IP created belongs to the employer, not the employee. They are especially important in tech, design, and creative industries. Clear IP clauses help prevent disputes and clarify ownership. Employers should draft precise language, and employees should understand their rights before signing. Positive workplace culture can reduce the need for restrictive agreements. When employees feel valued and engaged, they're less likely to leave or share sensitive information. Employers can focus on building trust, offering growth opportunities, and fostering loyalty. Strong culture is a powerful tool for retention and protection. Next, we'll discuss the role of onboarding and training in safeguarding business interests. Effective onboarding and training can help protect business interests by educating employees about confidentiality, IP, and company values. Clear communication and regular updates ensure everyone understands their responsibilities. Employers can use training to reinforce policies and prevent accidental violations. Investing in onboarding pays off in reduced risk and stronger relationships. Non-compete and non-solicitation agreements are used worldwide, but laws and practices vary. Some countries strictly limit these agreements while others allow broader restrictions. Understanding global trends can help multinational companies navigate compliance and protect their interests. Employees working abroad should research local rules and seek guidance. Next, we'll look at international examples and their implications. Europe, non-compete agreements are often limited by strict regulations, requiring compensation for affected employees. In Asia, practices vary widely, with some countries favoring employer protection. Understanding international differences is crucial for global businesses and employees. Compliance with local laws ensures agreements are enforceable and fair. Next, we'll discuss the future of these agreements and emerging trends. Future of non-compete and non-solicitation agreements is shaped by changing laws, technology, and workplace dynamics. Many states and countries are moving toward greater employee freedom and limiting restrictive clauses. Remote work and digital communication also challenge traditional agreements. Employers and employees must stay informed and adapt to new trends. Next, we'll summarize key takeaways and offer practical advice. Non-compete and non-solicitation agreements are powerful tools for protecting business interests, but they must be fair and reasonable. Employees should review contracts carefully, negotiate terms, and understand their rights. Employers should draft clear, compliant agreements and consider alternatives. Staying informed about laws and trends helps both parties avoid disputes and build strong relationships. Let's wrap up with practical tips for navigating these agreements. Employees always read agreements carefully, ask questions, and seek legal advice if needed. Negotiate terms to protect your career and avoid overly restrictive clauses. For employers, draft clear, fair agreements and comply with local laws. Consider alternatives like confidentiality and IP clauses. Both parties benefit from open communication and mutual respect. Navigating these agreements successfully requires knowledge, preparation, and collaboration. Non-compete and non-solicitation agreements are complex but manageable with the right approach. Understanding their purpose, structure, and legal context empowers you to make informed decisions. Whether you're an employee or employer, knowledge is your best tool for protecting interests and avoiding conflict. Stay updated on laws and trends and don't hesitate to seek expert advice. Thanks for joining us on this journey through workplace agreement. We hope you feel more confident and prepared to handle these important contracts.